Good morning, everyone, and thank you for joining my webinar on the guiding principles for obtaining a search order. So first of all, a quick introduction. You might not believe it, but that actually is me on that photograph. I am Mulla. I'm a barrister at number 5 Chambers, and I deal with all aspects of commercial litigation. It's quite varied, to be fair, often litigation with an overseas element. I deal with quite a few cases in Dubai and the DIFC. I also deal with lots of company cases and insolvency disputes. Now, in terms of search order applications themselves, the cases I've been involved in have again been varied. So they have been cases that involve unlawful means conspiracy, the conversion of goods, trespass to goods, passing off. So we can see how search orders can actually stem from a variety of different causes of applications. So the reason I decided to do this webinar was because I actually had a very good result on a search order a few weeks ago, and I thought, well, why not put a webinar together to go through all of the main principles. And I will be talking about that case generally, but I can't go into the specific details of that case. So in terms of the plan for today's webinar, this is the general layout of the principles that I'm going to discuss. But I really want to emphasize that I would really like today's session to be as interactive as possible. I would like to see lots of engagement in the chat box. I would like to know where people have came from, what experiences people have had themselves with applications for search orders, because we've had lots of people join from lots of different backgrounds today. We've got people from local authorities, people from different law firms, people from universities. So I think it would be nice if we could get a bit of dialogue going, so it's not a boring webinar. I don't want it to be boring. I want it to be as interactive as possible. So any thoughts or comments you would like to pop in the chat box, please go ahead, and that will help me have a bit of interaction with the audience, because it's just me looking at myself on this screen. So it'd be great to get a bit of interaction going with people who have joined from all over. So when we talk about search orders, when I talk to my colleagues about search orders or my instructing solicitors, the responses I often get are, oh, I don't know, Maria, they're a bit extreme, you know, they're a bit over the top, they're expensive, they're very difficult to obtain. And a lot of those comments are fair, to be honest. A search order is a very difficult order to obtain, because if it's granted, it enables not only the solicitor for the applicant to go into the premises, but also a whole load of other identified individuals, such as the supervising solicitor, to go into the premises, search them, and remove articles or documents for the purposes of obtaining information. So it's often seen as being a very extreme order, because the order is granted even before the respondents has had any opportunity to put their case before the court, because of course we know that search orders are always made without notice on an ex parte basis. And the main historic case that dealt with search orders emphasised again that the overriding principle upon which the grant of these orders are made is that of necessity. No such order ought to be made unless it is necessary in the interests of justice, and no order ought to be made in wider terms than is necessary to achieve the legitimate object of the order. So whenever I have a search order application, or I need to advise on a case where potentially I think a search order may be necessary, I have to think, can I really show that it is necessary? Can we really show with the evidence that we're going to gather that it will be necessary to make this application? And that is the undermining principle for these applications. So when we look at the jurisdiction of the court, this is a bit of statute for you. The jurisdictional power stems from Section 7 of the Civil Procedure Act 1997. And this is what I would refer to on my application notices, along with reference to CPR 25.1H. And this provides the court with the jurisdictional power to make the order to any existing proceedings or proceedings that are proposed. So you may have a claim that you're going to bring and you want to deal with the search order application to preserve that evidence as part of that claim. And the jurisdictional power enables the preservation of evidence which is or may be relevant, the preservation of property which is or may be the subject matter of the proceedings, and any person who is a party to the proceedings or who is likely to be a party to the proceedings can make any such application. And the jurisdictional power actually grants the party making the application to be able to enter the premises and to carry out a search for inspection of items identified in the order, or to make or obtain copies or records of anything else so described. So that is the jurisdictional power, and Section 7 of the Civil Procedure Act 1997, that's the only ever time I need to rely on this act really, is when I'm making an application for a search order. And as I've identified, I would also refer to CPR 25.1H, which again sets out the interim remedy. But also it's important to state that the practice direction to Part 25A also has a number of helpful provisions in terms of search orders and the requirements of any application. So it's also useful to have a look in there. So let's talk about method. And the method is very important because these applications can easily fail on the slightest thing, because we have to bear in mind that we've already discussed how necessary these applications have to be before the court will even consider giving them a chance. So if there is any slight doubts on the application itself, then it simply won't succeed. So it's really important that everything is boxed off. So it's an application that's made without notice. I always like to refer to the statutory jurisdiction in Section 7 and CPR 25.1H. On the application notice itself, I like to see an explanation setting out exactly why the identification and preservation of the items in the draft order are necessary. And it will also need to be accompanied by a detailed affidavit prepared by the solicitor for the applicant with supporting exhibits. And also I like to see separate affidavits prepared by the supervising solicitor, and we will come on to those much later on. I always request the case to be heard by a High Court judge. Now, I do think that actually a district judge does have the power to deal with search order applications, but I've never dealt with one before a district judge. They've always been dealt with by a High Court judge. And if I have an intellectual property case, the application will need to be made in the Chancery Division, or I will need to ensure that the application is marked to be heard by a High Court judge who is able to sit in the Chancery Division. Now, on my applications, what I always like to consider is if I need to make an alternative limb to the application. So perhaps not just only an order for the search in accordance with Section 7, but I also like to have a think about whether or not I want to have an alternative limb to the application. So often what I might do is I might have a second part to the application, which is alternatively an order for the delivery up of goods in accordance with CPR 25.1, or an order for disclosure of documents or inspection before her claim has been made in accordance with CPR 25.1C. And this often helps me, because if a judge is on the fence with an application and he's like, Miss Muller, I'm not with you about this search order, I think it's over the top, I don't think it's necessary, then I always have the alternative limb there, just in case, so that I can turn around and say, well, if you are against me on this, then alternatively, I would seek this lesser order. So I think that's helpful to think about that when we are drafting the applications themselves. So the legal test, the court will still insist on the applicant being able to demonstrate some elements of fraud, some elements of dishonesty, or the imminent removal or destruction of evidence. And going back to what I've said previously, the underlying principle in these cases is necessity. That is the overarching principle that the court will be considering. Is this application absolutely necessary? And in all the cases, there are 5 main conditions that have to be satisfied. And there were the 2 main cases, the BMW case, that was an intellectual property case, and also the Indici Salus Limited and Chandrasekaran case, where the 5 conditions were identified. And these 5 conditions tend to be clear from all judgments in relation to search orders that we will see. And all the cases that I deal with, the court always individually sets out these 5 conditions and considers, has the 5 conditions been met in this case? So the first condition is that there must be a strong prima facie case of a civil cause of action. So you have to have a really strong claim lying in the background to be able to mount an application for a search order. And this is where an application for a search order will differ from an application for, say, an interim injunction, where all you have to be able to demonstrate on an application for an interim injunction is that there is, on the balance of probabilities, a serious question to be tried. But in search orders, the court will want to see that actually there is in fact a strong prima facie case of a civil cause of action. You've got to have a strong claim. You've got to be able to demonstrate that in the affidavit. And also you've got to have some good particulars which plead a strong claim and a strong cause of action. For example, in claims for instance, a lot of the search orders I've dealt with have been in relation to trespass to goods and unlawful means conspiracy. In those cases, the court has always wanted to see detailed evidence in the affidavit supporting the claim, such as surveillance evidence, photographs, evidence of test purchases, evidence showing that goods have been used wrongfully by the respondent, and any other evidence of dishonesty or wrongdoing by a respondent. So I would like all of that evidence to be set out in the affidavit, so it really demonstrates the underlying basis of the claim. But it's also helpful when we come on to deal with the other conditions that have to be met when granting a search order. So the second condition is that the damage to the applicant to be avoided by the grant of the order must be serious. If an order is sought to prevent the destruction of evidence, the evidence must be of critical importance. So you really have to consider here, is the applicant able to demonstrate that the damage that they are seeking to avoid is actually quite serious, and that the evidence that they want to get hold of is of critical importance to the claim itself. So I've dealt with a lot of cases concerning the unlawful filling of, say, LPG cylinders, where in that industry there are lots of third parties who often try and set up their own business, and compete with the main dealers, and they then go about by, in many cases, filling up the cylinders themselves, using the cylinders as their own. Now, in those cases, I'm able to demonstrate that, look, here there is a real health and safety consequence of these actions that are being undertaken on a regular basis by the respondent, and that if those cylinders are not retrieved and taken back into the hands of the claimant, the public safety concerns could be massive. The health and safety consequences could be massive. The reputational damage to the applicant could be massive if those cylinders, for instance, were to go on and anything was to happen to those or to anyone who was using them. So in those cases, it's a lot easier to be able to demonstrate that, look, there's real danger that can be caused here, real damage. And also, it's easy for me to be able to explain that those cylinders need to go back into the hands of the applicant to prevent that evidence being destroyed and potentially sold on somewhere else. So that's a practical example. So the third condition is that there has to be clear evidence that the respondents had in their possession incriminating documents or things. So this is where you really need to be able to show that if you are going to make such a serious application for a search order, that what you are seeking to obtain as part of that search order is actually going to be there when you get there. And the court will want to see clear evidence that, look, these items, these goods, these documents, this computer data is actually going to be in the hands of the respondent when you get there. So, for instance, this is where the photographic evidence comes in useful, or surveillance evidence of items being used by the respondent unlawfully. And you have to have a strong argument to be able to satisfy this third condition, that the respondents actually have these items in their possession. Now, the fourth condition is the condition that actually causes me the most concern in my applications. It causes me the most, I wouldn't say sleepless nights, but it keeps me awake, where I think, have we satisfied the fourth condition? Because in my mind, it's quite a difficult condition to satisfy. So there has to be a real risk of the destruction or removal of evidence, and it has to be a good deal than merely possible. So you can't go to the court and say, look, you know, these days these people are moving these items to other locations, and this is what we're concerned about that they are going to do in this instance. You have to be able to show that there is a real risk of the destruction or the removal of evidence. And it can't be a slight one. You have to have some real concrete concerns that you are going to be able to persuade a judge that this can actually happen. And this is often where a judge will say to me, well, Miss Mulla, rather than, you know, going down the line of a search order, would it not be possible in this case for us to simply have an order for delivery up, a doorstep delivery up order, where you simply go to the house and ask for the belongings to be brought to the door, rather than requiring entry to the premises? And you have to be able to demonstrate here that actually those lesser orders are not going to satisfy what the applicant wants to achieve here. And in doing that, you have to really be able to point to some previous evidence of wrongdoing by the respondent, be able to demonstrate that actually perhaps the respondent may not be that forthcoming if you were to knock on the door and ask for various items to be delivered up to you, that previous history or a previous course of conduct shows that actually in previous occasions they've actually been quite deceitful about how they've dealt with matters or conducted themselves. So is there any evidence of the respondent's motive to conceal their activity? Is there any evidence of them having previously acted dishonestly that we can rely upon to demonstrate that actually a respondent is not really going to comply with a lesser order, such as a delivery up order? Because that's what we have to bear in mind when the court is dealing with this application. They are always going to be thinking, look, is there any alternative that I can make rather than make this application for a search order? Because it is such a draconian extreme order, we have to be able to demonstrate, well, no, none of those lesser orders will actually be sufficient. It's only a search order that will give the results that we require. And so there has to be a real reason to believe that the respondent will not simply obey any other order other than a search order. And that's why it's necessary to go into the premises without notice, because the reality is that they're not going to be forthcoming with what you need otherwise. And there are many search order cases where condition 4 has been satisfied. And this is where we can really see where search order applications are made in such a large context of cases. You can have them in insolvency cases, applications by trustees. You can have them in breach of fiduciary duty claims. You can have them in the trespass to goods cases that I've also referred to previously. In the case of Umut and Uktan, condition 4 was satisfied as there was evidence of money moving between accounts and false documents that the applicant could rely upon to say, well, look, you know, this is why condition 4 is satisfied and the search order is needed. In a LPG case, not one that I've dealt with, the case of Calagas Limited and Chorley, there was evidence of the respondent hiding unlawful filling equipment and evidence of previous convictions for dishonesty offences. So I don't think the evidence of previous convictions is one of the strongest things to go on, but that was all part of the parcel of the evidence that the court had of being able to demonstrate that actually condition 4 is satisfied here, because there is evidence that the respondent will only be able to deal with a search order. No other order will be sufficient. No delivery up will be complied with. It is necessary for there to be a search order. In ArcelorMittal USA and SR Steel, and again, this demonstrates again the context of search orders. This was a combined search order and application for a freezing injunction that was made following an arbitration award being granted. And in this case, there was evidence of asset dissipation on a massive scale and evidence that a computer had been deliberately withheld, and emails where discussions had even taken place about documents being hidden. So again, this is really good evidence that you want to get. You know, if you've got an email trail where people are talking about how to hide various evidential aspects, that is excellent to be able to demonstrate the risk of removal of evidence. But it is condition 4, which does cause me the most concern in my applications, because it's not the easiest condition to satisfy, and it's something that we really have to make sure that we do bottom off, because if not, a court will say, well, no, that order is not going to be made, and a lesser order for delivery up may be made instead. So the final condition, and this is the easiest condition in my opinion, that is the harm likely to be caused by the execution of the order to the respondent and his business affairs must not be excessive or out of proportion to the legitimate object of the order. So this is not a difficult condition to comply with. This is basically where at the end of your submissions, you're saying to the judge, well, in the round, look how proportionate this application is. It's only a search order, for instance, in respect of part of the premises. It's only the commercial aspect of the premises. It's not the residential premises. So the harm is being minimised to the respondent. And actually, the overall damage that could be caused to the applicant completely overrides any harm that could be caused to the respondent anyway. And if there is any harm, or if there is to be any challenge to the search order and the legitimacy of any search order being granted, that can be raised on any return date. And always an applicant will be required to provide a sufficient undertaking in respect of costs to cover any respondent for any potential harm or damage that has been caused where a search order was not justified. So it's not a difficult condition to satisfy the final condition. So I've mentioned a supervising solicitor, and this is why often people are a little bit reluctant to make applications for search orders, because it's not something that entirely the applicant can do themselves. They have to also instruct an independent firm who will be the supervising solicitor for the application. And effectively, you can't just pick any supervising solicitor. They have to be a law firm who are experienced in the execution and supervision of search orders. They have to be able to demonstrate that they will be able to comply with the requirements of how complex actually executing a search order is, and the legal requirements that have to be undertaken to ensure that everything is actually adequately explained to the respondents. So they take an independent role. They oversee the execution of the search order on the day, and they ensure that the terms of the order are complied with. They are responsible for serving the order personally on the respondent. They are responsible for explaining the terms of the order to the respondent in everyday language. And they have to be able to advise the respondent of their right to be able to obtain legal advice, of their right to be able to vary or discharge the order, and explain to the respondent about legal professional privilege and the privilege against self-incrimination. They are also responsible for compiling a detailed list of the search and to make sure that any items are properly recorded and removed accordingly from the premises. So the supervising solicitor actually has quite a hands-on role on the day in question. And they will be there from the very start, and they have to ensure that everything in the terms of the order has been complied with correctly. So with my application and my affidavit of the claimant, I also like to see a detailed affidavit from the supervising solicitor setting out all of their past experience with search orders and just getting them to confirm that they will agree to the undertakings as specified in the draft order and will ensure strict compliance with the terms of the order itself. They will confirm that they are happy with the undertakings, and they will confirm that they will prepare a follow-up report, because they will prepare a report which effectively discusses everything that happened at the search, everything that was retrieved, and this will be considered by the judge on the return date. And I'm always very excited to receive the report of the search because it sets out everything that's happened as the basis of the application. So in terms of the draft order, there is a draft order which can be used as a starting point, I would say, because the orders have to be very carefully drafted. And that's contained at the Practice Direction A to CPR Part 25. But essentially, the order needs to contain the penal notice. It needs to set out who must comply with the order, including any respondents, employees, So it may be that actually you're at a commercial premises and you don't just want the respondent to comply with the terms of the order, you also want his employees to comply with the terms of the order. But the order will need to specify those individuals who are permitted to undertake the search. So a court will be very careful to ensure that not just everybody can turn up at the search and get involved. The court will want to see actual named individuals who are going to attend, who are required to attend only because it's necessary for them to be there. The court will be very careful to make sure that there's not a whole load of people turning up who are not necessary and required as part of that search. The order will also need to clearly identify the premises and the land that will be entered, and I like to see a title plan with a copy of the title register, because a court again wants to be sure that they are aware of exactly how this search is going to be executed on the day in question. The order will also specify any restrictions on the search, the listed items that are required to be delivered up, and any prohibited acts, for instance, warning anyone of the existence of the order or that proceedings have been brought. And there will be various schedules of the order, which will set out the various requirements for service, and also will set out the various undertakings. And these are specific undertakings that have to be provided by not only the applicant, but also the supervising solicitor. So it's really important that both the applicant solicitor and the supervising solicitor in their affidavit evidence confirm that they are aware of the undertakings in the draft order, and of course they will comply with them. So just briefly, let's have a think about some practical considerations that we may need to have a think about when we're making an application for a search order. So we know that, well, I know from my experience that whenever I get some papers in for a search order, it needs to all be dealt with like yesterday. Everything needs to be dealt with as soon as possible. Everything has to be dropped. Everything needs to be drafted. The court needs to be liaised with to get an urgent listing without notice. And then we also need to ensure that not only is all of that in hand, but actually that the applicant has made arrangements to ensure that the search can be executed promptly, that the supervising solicitor can also get to the search premises and be there promptly. And you also need to consider, what kind of manpower is needed for this search. Often where we have searches where there are a lot of goods that need to be retrieved, it may be necessary to have lorries that are able to take the possessions away. So all these arrangements need to be made in the background really quickly. We may also need to consider, do we need any experts to be present? For instance, are we looking to retrieve any technical information? For instance, are we trying to receive data from a computer or anything like that, where you may need an expert to go in and to deal with the retrieval? Again, you would need to be setting out the terms of that in the affidavit and also in the order itself. A really important consideration is, are the premises to be searched actually under the possession and control of the respondent? And again, this is why I like to have a copy of the title plan and the title register, where in an ideal world, you can easily marry up that, look, these premises are clearly in the possession and control of the respondent. But what you don't want to do is go to all the effort of obtaining a search order and find that you can't execute the same because you're faced with an argument that actually, well, that part of the premises is not actually controlled by me. So you will need to really demonstrate that the premises to be searched are under the possession and control of the respondent. If you're not satisfied with just a title register and plan, have a think about whether any surveillance evidence might be needed to be able to show to the court, look, this is the outline of the premises, this is what we can see, these are the boundaries, these are all within the possession and control of the respondent. Or perhaps we can demonstrate that there has, for a period of time, been a previous course of dealings with the respondents at the premises. That's also very helpful evidence, where you can say, well, look, these premises are definitely in the possession and control of the respondent, because we've delivered a number of items to there over consecutive months or years. So, you know, they can't raise an argument that those premises are not within their possession and control. Once an application for a search order has been successful, it's important that nobody really relaxes until the search has been executed. So I always say to my instructing solicitors, look, please make sure you take a full detailed note of any conversations or any evidence that take place throughout the search, or any comments that are made, because these can form the basis of a useful affidavit on the return date if we are going to be faced with any arguments about the search being excessive or search being disproportionate, for instance. You know, if we can have evidence of those responses and those conversations, again, that is really helpful. Finally, executing a search order can take a very long time. It can take a full day. Often people have to go and stay overnight. I've always been asked if I want to go along, but unfortunately I've had to decline, because I'm not really going to be doing anything of any use. I'll just be an individual that would not be required as per the order, although I would love to go and see a search order being executed. So what if a respondent refuses entry? It's highly likely that if you get there and a respondent says, no, you can't come in, that would be a possible contempt of court, but it would need to be more than a trivial breach, and then you would have to go back to court to deal with that. So we've got our search order. We've obtained a detailed list of all the items and documents and data that has been retrieved as part of that search order. Ideally, your solicitor or the solicitor has prepared a follow-up affidavit setting out any useful evidence from the day of the search. Ideally, we have a very good report from the supervising solicitor, which sets out everything that happened on the day. And at the return date, these documents will be considered in addition to any other evidence that's filed by the respondent seeking to challenge the search order. And often they will say, well, I was always going to give over these items, all you had to do was ask. And that the order is totally disproportionate and unnecessary, and then there will be various arguments on cost. But the reality is, more often than not, particularly in circumstances where a judge has been overwhelmingly persuaded that this order is necessary, those are very difficult arguments to advance by a respondent, in my opinion. And from the search orders that I've been involved in, the evidence that came up from the day of the search has actually turned out to be far more compelling than what was ever previously anticipated as part of the application. The things that have came out of the woodwork, and that the vast quantity of items that have been retrieved has been really exciting, because it's been able to demonstrate that actually, well, we were more than right to go for this application for a search order, and the respondent was never going to be forthcoming in terms of handing those things over. Okay, so that brings me to the end of my slides, and it's now 1:45. Let me just check the chat box. So I've had no chat from anyone. Now, does anyone have any questions or any observations or any experiences that they would like to talk about, please pop them in the Q&A box now or in the chat box now. Maria Tariq says, can we know your career journey, please? Okay, well, that's a bit of a out there question, but yeah, of course. I'm a barrister. I qualified as barrister in the normal way. Before I became a barrister, I started off actually doing a lot of internships and voluntary work and stuff like that. And yeah, I've just been a barrister for about 13, 14 years. And so that's my career journey. Not very exciting. Any other questions? Okay, what are the likely costs in seeking a search order? Well, this is often where people, take a bit of a gasp, because you have the costs of the supervising solicitor that they will charge. Now, they will often they will be expensive. So, you look in the thousands, often over £10,000. And it depends how long the search is going to take as well, and how long they will be required to be on the premises and the extent of the search. You might need 2 supervising solicitors to attend. So those are the costs in relation to that. You also then have the costs of the solicitor preparing everything for the application itself. Again, that's not cheap. You've got the cost for counsel. Again, that's not cheap. And then you've got the cost for the hearing itself, and then the return date. So they are expensive applications, but this is why they have to be necessary, and they have to be necessary to go to the heart of your case. And if you are successful, then often the other side will end up paying your costs, subject to those being reasonable and being assessed by the court. So, in the cases I deal with, often we get the costs back. Not all of them, but a large proportion of them. Another question we've had is, can an interim injunction not achieve the same purpose, especially when it has a lower threshold, i.e. a serious question to be tried on the balance of probabilities? Well, the answer for that is no, because an interim injunction will not give you the power to go in and retrieve those documents, those goods, those belongings that you want to get. So an interim injunction can only go so far, and you will need to apply for a search order if you actually do need to enter premises to retrieve those items. So no, an interim injunction is not good enough, I'm afraid. Please, could I have a copy of your slides? Yes, of course. Okay, right. So nothing else, then we will bring the webinar to a close. Thank you so much for coming today and listening to me. These slides will be made available. If you have any queries about search orders or anything in general, please just contact me on the email below. You have the details also for my clerks and the respective phone numbers. So if you need anything at all, please just reach out. And I hope you enjoyed it, and hopefully you found it very useful. So thank you very much.